Welcome to the Kessler Law Firm podcast. If you'd like to connect, you can find the link to our website along with directions to our office in Fort Pierce in the show notes of this episode. Attorney Michael Kessler has been providing criminal defense and protecting the rights of citizens on Florida's Treasure Coast since 1985 and has been designated by the Florida Bar as a board-certified criminal trial specialist. With a solid record of success spanning over 40 years, attorney Michael Kessler has proven that more people are wrongly arrested for drunk driving than any other crime on the books. And now, here's Michael Kessler.
Good morning, folks. Welcome to another episode of the Kessler Law Firm podcast. As you can see, I'm joined by one of my favorite guests, Cliff Barnes. How are you this morning, Mr. Barnes?
Good morning, sir. It's a Monday morning, but other than that, we're doing great.
I thought we would talk a little bit about current events. We've been talking at the office about these ICE shootings up in Minnesota. And of course, you know that there was a shooting in my neighborhood a couple of weeks ago. And they all have the same sort of core issues. Was the shooter acting in self-defense? How does stand your ground come into play? And in the case of my neighborhood, was the shooter making a legal citizen's arrest? You want to tackle any of those three?
I just like a nice, pure citizen-on-citizen self-defense. I can talk about that.
All right. Let's hear your take on citizen versus citizen self-defense.
Well, I just had a big trial. My client was facing 2 life sentences. I was brought in as co-counsel by the infamous Juan Torres. It was Juan's last trial because of health issues, but we had an excellent self-defense fact scenario, and we went with it and convinced the jury to convict him of only one lesser offense called felony battery without a weapon, which saved him 2 life sentences that would have occurred from a conviction as charged of aggravated battery, and the second count would have been burglary of a conveyance, a vehicle, with an assault or battery.
Well, Cliff, that's a great outcome. Tell us about the facts.
Well, I'm pretty good at self-defense cases, and when I see one from afar and I examine it, I usually can tell if it's one that the jury will look kindly on or laugh at. In this case, we had 2 convicted felons. Both had 3 prior convictions. Both took the witness stand. The state's accuser, we never use the word victim in a self-defense case. The accuser says that my client basically for no reason walked up to him in his vehicle and began stabbing him with something sharp, presumably a knife. And of course, this was a kind of a love triangle where the 2 men were both having some type of relations with the female, and the accuser drove to the house where my client frequented and dropped the girl off, and claimed that as he was dropping her off, soon after, our client stopped his truck in the middle of the road and began stabbing him without warning.
It doesn't sound like self-defense.
No, except that the accuser had the night before sent threatening texts to the girl, the woman, telling her that, accusing her of sleeping with my client, telling her she was a liar when she denied it. Of course, she was. Not that that's real relevant, but so he was extremely possessive, extremely jealous, and he actually put in the text to tell my client to watch his back. And then the final text was, "Oh, I'm going to drop you off. Tell Mike," the defendant, "tell Mike to be there." And her response was, "Okay." That was the very night before the night that this happened. So clearly we have a motive, opportunity of the accuser to attack my client with a knife. My client happened to be a MMA trained fighter and was able to, according to him, was able to wrestle the knife either away from the accuser or when the accuser attacked him with it, ward off the blows so the accuser stabbed himself several times.
Well, just as an aside, for those of us, those of you out in the audience that don't know us well, even though Cliff said his client's name was Mike, it was not me.
Yeah, I don't think you could have taken the knife away from this guy.
Well, I'm not. My training in MMA is all over the television.
Okay, okay. Well, maybe you
So,
could have then.
so give us a little bit of background. What is Florida? How does Florida describe self-defense under the law?
Well, it's a magnificent, magnificent, magnificent defense because I believe it is the only defense where the state has to disprove it beyond a reasonable doubt, has to rule it out. You were kind enough before trial to give me a book called Rule It Out, I believe. And it's a book that tells us trial lawyers to stop pretending that we're going to be like Jerry Spence and able to seduce a jury and give them such good arguments and tell homey stories and get them on our side to the extent they're going to find our client not guilty because our theory of the defense was believable. Um, I was trained, unfortunately, believe just that if I was good enough lawyer, I could twist the facts and convince the jury of my case, forget the state's case. But that book reminded me that the whole job here of the jury and myself, the jury has to look for reasonable doubt. And all I have to do is give them reasonable doubt. But you have to constantly remind the jury in opening, in voir dire, even in questioning witnesses. I had the state's expert, the last question I asked, can your evidence rule out self-defense? Use the words rule out. No, sir, was his response. And then the next state witness, can you rule out, after all this evidence you've brought to us and told the jury, can you rule out self-defense? No, I cannot.
All right. Well,
So,
Cliff, most of our followers here are not themselves lawyers. So let's take a step back and instead of trial tactics, tell people what Florida says is or is not self-defense.
oh, okay. Well, they passed the stand your ground. And stand your ground simply says you can meet force with force if you're where you have a legal right to be, if you're out in
Well,
public.
just for some background, as self-defense as a legal defense developed in across the country. I mean, every state has its own versions of it, but there was, bottom line self-defense is in the right circumstances, I'm allowed to use force, sometimes even deadly force, to protect myself or someone else from the imminent use of deadly force, either
Yes,
against me or against that someone else. Now, that's the key to self-defense generally everywhere in
sure,
America.
sure.
But a lot of states developed what is called the castle doctrine. The castle doctrine says your home is your castle and you don't have to retreat from your castle. But if you were confronted with the threat of force before you could return force with force, you had to retreat.
Correct, right?
You had to retreat and you had to attempt to avoid use of force by retreating unless you were in your own home. in your own castle. Now,
Yes, sir.
the stand your ground concept, the stand your ground law that's now the law in Florida says you don't have to retreat from anywhere anymore.
The world is
Right?
your castle.
The world is your castle. So if I'm confronted in a parking lot, I had a case a year or so ago where a senior citizen was confronted by a person he believed was a mugger in the parking lot of Dollar General. He didn't have to retreat. He was entitled, as a matter of law, to defend himself. And
Correct.
he could, and the law said he could meet the force he was threatened with equivalent force
Or greater.
or greater.
If you
Well,
have a belief that's reasonable that you're going to be greatly harmed or killed, you can, even if you're being attacked with someone's fists, you can pull out a gun and shoot them. Now, that's for a jury to determine, but if you have a attacker who's big and young and strong, he could easily kill a elderly man like you and me with his fists,
so
bare hands.
so in the context of your case, the accuser, who it seems like was actually the assailant, he threatened physical harm both in his text messages the night before, which wasn't imminent, but when he showed up armed at the scene of the event, that was an imminent danger of death or serious bodily harm to your client.
Absolutely. When that knife came out, according to my client, whether it did or not, I wasn't there and you weren't there and no one was there except those two, but they both told totally different stories about what happened. But yes, once that knife came out, all bets are off. If my client had had a gun, he could shoot him.
So your client was entitled to use even deadly force to protect him from the reasonably apparent threat of deadly force to him.
Correct. Correct. And like you
And
said, Florida law back in the day when we were coming up as baby lawyers was that self-defense, the only place you could really meet force without first having a duty to retreat. In other words, you had to turn your back and run if somebody came at you before using deadly force. And now you do not. As you said, the castle doctrine, now the whole world is your castle, unless you're doing something illegal or you're trespassing in someone's home or breaking in, or if you're doing something illegal, then you can't claim self-defense when the victim retaliates or opposes you.
so if you're the person who initially creates the danger, then and your victim, the victim of your threat, threatens to use deadly force to defend himself, you're not then entitled to use deadly force yourself.
That's correct. So,
Okay.
but
It'll be
it's always going to be a witness versus witness, you know. So
right. Well, it'll be interesting to see how that plays out in the shooting I mentioned that was in my neighborhood. According to the newspaper account, um, one of my neighbors comes home um, and she sees a stranger in her driveway holding some sort of a bag, a gym bag or something like that. She gets safely inside her home and calls her neighbor across the street. He comes over with a gun. The newspaper doesn't describe what either man said to one another, but my neighbor apparently held him at gunpoint while the lady called the police. The police were on their way. Something happened between the two men that caused my neighbor to shoot the other man in the leg. So, this situation, as it plays out, and I don't have firsthand knowledge, I haven't talked to any of the parties, and I'm not the lawyer on the case, or at least I'm not yet.
well, send him
Um,
my way.
anyway, this will probably come down to which of them raised the specter of deadly force first. And there's somewhat of a wrinkle that we can talk about in another podcast, but Florida does still recognize the legality of a citizen's arrest. So I don't want to get too deep
Fascinating.
into that right now, but two different courts, including the Florida Supreme Court, ruled just recently that citizen's arrest is still valid, legal under Florida law. So it may be that the neighbor was effecting or trying to effect a citizen's arrest. In that case, he would have been lawfully entitled to use some amount of force.
There's
And
so
he would,
so many facts in that case that are fascinating because it could have been an accident. I thought I read
it,
where he shot into the ground just to warn the guy. Well, maybe it was an accident in self-defense. It's very convoluted.
it may be. If in fact the neighbor with the gun was trying to effectuate a citizen's arrest and was doing it legally with sufficient legal grounds, doing what the police could have done if they had been there, then he would have been acting legally in standing his ground.
Right.
If, on the other hand, he didn't have any right to be making a citizen's arrest because there was no probable cause to believe that man was committing a crime, then he may have some troubles down the road.
But remember, with self-defense, you can be defending someone else.
You can,
So
but
if that gentleman, the person who was shot was making threats, verbal, and he had a bag with who knows what in it, then you have self-defense. So you have so many different wrinkles in this case.
it'll be interesting. We'll follow this case as it goes through. Whether you or I end up defending this gentleman or not, we can still keep an eye on it and talk about it. And I
Absolutely.
think we'll do this again in a couple of weeks and see
Great.
if there's any updates.
Okay, great.
Thank you very much for joining us this
Thank
morning,
you.
Cliff. And that'll wrap it up for another episode of the Kessler Law Firm podcast.
Thanks for listening to the Kessler Law Firm podcast. If you'd like to connect, check the show notes of this episode for a link to our website and directions to our Fort Pierce office. Whether you're watching this on YouTube or listening to it on your favorite podcasting site, please click subscribe or follow so next time you come back, our podcast episodes will be ready and waiting for you.